Ladies and gentlemen, welcome to the National Constitution Center. It is great to see old friends and new, and I'm so thrilled to welcome you. I am Jeffrey Rosen, the president of this wonderful institution, which, and now I feel like calling on you because you're in the first row, as you certainly know, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. We have a superb set of town hall events coming up during this exciting spring. On May 26th, Privacy in the Modern Age, the Search for Solutions. May 27th, the beginning of the Bill of Rights with Carol Berkin. Then on June 2nd, an intelligence squared debate about whether or not the Constitution requires states to recognize same-sex marriage. That will take place 2 days before the opening of our new exhibit, The Constitution, Gay Rights, and the Supreme Court, and it will take place just weeks before the Supreme Court hands down its historic decision on marriage equality, which we will commemorate with another talk on June 9th with the author Kenji Yoshino about the Hollingsworth against Perry case that gave rise to the whole debate. So it's going to be a great month at the NCC, as it is every month here in constitutional heaven. However, ladies and gentlemen, I have to tell you that in constitutional heaven, the partnership that means the most to me, I think the one that has done the most to elevate constitutional debate in America, is one with Caroline Fredrickson, whose superb book you were just about to hear about, and her counterpart at the Federalist Society, Lee Otis. Through Caroline's vision and that of Lee Otis, we have been able to bring together these two great organizations, the American Constitution Society and the Federalist Society, to sponsor a series of debates, symposia, and traveling town hall debates. We think that, like the Lincoln-Douglas debates, these have the potential to transform constitutional discourse in America. We've taken them on the road. Last week we were in Boston for a town hall debate on the Citizens United case. The month before, we opened in Washington at the National Press Club for a debate about the Hobby Lobby case. And on June 16th in New York City, we're going to debate the constitutionality of NSA surveillance, a blockbuster with Deborah Pearlstein of Cardozo and Michael Mukasey, the former Attorney General. It is exciting that thanks to the vision of Caroline and Lee, these two organizations are traveling across the country, nominating the finest scholars in the land on the liberal and conservative side to debate each other respectfully. These are all being podcast and live streamed. I just can't tell you, in Boston last week, we were in the John Adams Courthouse, near where John Adams had denounced the writs of assistance. And seeing these two great organizations joined together through the hosting of the National Constitution Center to debate Citizens United was incredibly meaningful and exciting. So that is a long way of saying that I'm so grateful to Caroline for her vision in having embraced this unique partnership, and I am so proud of what we're doing together. In addition to being a great leader of the American Constitution Society, Caroline is a legal intellectual of the highest order. She is a student, as I've learned recently, of Aristotle and Aristotle's connections toward contemporary issues, which include gender equality. And she's just written this superb new book on gender equality, Under the Bus, which you're going to hear about tonight. I'm going to now turn the show over to my friend and another great National Constitution Center partner, Lynn Yankel, who will introduce Caroline properly. But I'm just so grateful to Caroline for being here and for the visionary work she's doing on behalf of constitutional debate. Lynn Yankel is a friend of many of us here and a longtime friend of the National Constitution Center. She has been director of Drexel University's College of Medicine Institute for Women's Health and Leadership, and she's the founder and co-chair of Vision 2020, which is a national 10-year initiative which will culminate in a commemoration of the 100th anniversary of the 19th Amendment, which gave women the right to vote. That'll take place in the year 2020. It'll include bang-up discussions and symposia and an exhibit at the National Constitution Center, and we're so proud of our partnership with Vision 2020. Ladies and gentlemen, please join me in welcoming Lynn Yankel.
Thank you, Jeff, and we love this partnership. Vision 2020 is about the unfinished business of women's equality. And as we look to the year 2020, which is now only 5 years away, we have lots of work to do to accomplish our national goals, which are shared leadership among women and men, 50-50 by 2020 in business and government, economic parity, which means closing the pay gap as well as the retirement income gap that exists because of gender, civic engagement, which is more women voting and more women running for office, and educating our young people to value gender equality. So today's program, which is one of a series of programs that we are doing as partners with the National Constitution Center, is a perfect example of how we are moving toward these goals. And Vision 2020 is a national coalition with delegates in all 50 states and allied organizations that represent over 22 million people. So we are aligning our efforts and working together toward these goals. And I am so pleased to be here today to introduce our wonderful speaker and moderator. So, Caroline, why don't you come out? And I'll introduce you first, since Jeff already talked about you. Caroline Fredrickson, as Jeff told you, is the president of the American Constitution Society, which is the nation's leading progressive legal organization. It has chapters on college campuses, in law schools, in nearly every law school. It has 40 lawyer chapters across the U.S. And it is a very important organization that we are looking forward to working with at Vision 2020. Caroline is a graduate of Yale University and has her JD from Columbia. She has written a book, which we're all going to have a chance to buy, and I'm really looking forward to reading it, called Under the Bus: How Working Women Are Being Run Over. And it is about the status of women in the workplace and women's rights. So it's going to be a very important discussion that we're about to hear. Moderating this discussion, Oprah-esque, as she says, is Professor Ann Boylan. Ann, come on out. Ann is a professor of history at the University of Delaware. Her expertise is in 19th century and women and gender, and Ann has published many publications and has another book coming out this year on women's rights and suffrage. So I will turn the program over to Ann, and again, we're just really appreciative of their being here and of this terrific partnership that is going to educate all of us. Thank you.
Thank you, Lynn. Thank you, Jeff. We're very pleased to be here and pleased to see such a nice audience. This is Caroline's hour, so I want to give her plenty of opportunity to talk about her very interesting, very readable book. So I'll start with the sort of basic kind of question that one usually asks, and that is, what led you to write this book? What developments were you observing that you thought needed to be explored in a book-length study?
Well, first I just want to thank the National Constitution Center and Lynn and Jeff and Ann here for being here today to talk about these issues. But so, you know, I think one of the issues that caused me to want to write the book was that, you know, I was, like many women, heard a lot about leaning in and about opting out and about sort of the sort of a dialogue that was going on at a certain level about, you know, how do women deal with work and family. And I paid a lot of attention to this because I actually started my career in the law as a labor lawyer, doing labor and employment issues, and I'm very much interested in sort of women and workforce questions. And I sort of went back to that and I started thinking about what wasn't being talked about, because, well, I don't dispute that. I think, you know, Sheryl Sandberg is onto something. I mean, there are cultural barriers that inhibit women from being as successful as they might be. There is a certain amount that's internal that we need to learn about and talk about, but so much is external. And I think for most women, leaning in isn't really the main issue that needs to be addressed. They're really desperate to have affordable childcare. They really want to be able to take leave when they're pregnant and they're having a baby, but they can't because they're part of the 40% of the workforce that's not covered by the Family and Medical Leave Act. And even if they are covered, they might not be able to afford unpaid leave. These are women who are struggling because they home healthcare workers, and they're not entitled to overtime, and even if they're working 80 hours a week. And so I started thinking a lot about, what are we not talking about, and what do we really need to talk about that's affecting the vast majority of women?
And I was interested, you used two terms that I think are all over the news media: opt-in, opt-out, whatever, lean in. But you developed your own term, which I think is actually a little bit more accurate, and that is left out. Could you want to say a little bit more about what, in your view, which women are the ones who are able to or not able to lean in, and which women are the ones who are left out of this conversation?
Well, so we were talking about in the green room that I'm the daughter of a historian, and one of the things that I learned from him was how history does explain a lot, and I started thinking about not just what our labor law doesn't do. We don't have certain types of protections, but who's actually left out of what we have. And it sort of led me to start reading a lot of history of the 20th century development of our major set of labor and employment laws. And that is around the New Deal, when Congress was finally able to have upheld by our Supreme Court a series of pieces of legislation that provided minimum wage and overtime, that allowed workers to join unions without being penalized. And then later on, we adopted legislation that prohibited employment discrimination against women and minorities. And as I started thinking about and looking into those histories, I looked at some of the discussion. It's particularly dramatic during the New Deal, when what you had was and I know you as a historian are very familiar with this story, but deal making is deal making. It happens when you're passing legislation, and I worked on the Hill for a long time, and I know that's sort of the way that things get done. But we need to kind of look at that history of our New Deal legislation and see what those deals entailed. And at the time, you had a southern economy that was very rural, very agriculturally dependent, and still had a lot of the same same structural issues that it had in the 19th century. So there was a real interest from the Dixiecrats of protecting the economy that they had, which was dependent on African American labor, and they wanted it to be kept at a very low paying level. They didn't want them to have the right to join a union, and they didn't want to have to be covered by the minimum wage and overtime. And that's what that affected was agricultural workers who, by the way, at that time and still are quite not dominated by women, but they are a large percentage of agricultural labor, but domestic workers, where you had the vast majority were women. And these were women who were working on the plantation, but working in, taking care of people's kids. But those exceptions, those exemptions from the law have not been fixed. And so we've carried forward these same limitations, and that category of domestic worker has just grown astronomically, because we're now including again, vast majority of workers in this category who do home health care are women, predominantly minorities, many of them immigrant. And it is because of the aging of our population, this is a category of worker that is just growing. And these general category of workers are those that are seen to be, by our Department of Labor, the ones that are going to grow the fastest in the future. So we have to deal with the fact that we have this population that's not protected by, depending on the exact worker, but the Fair Labor Standards Act, which is minimum wage and overtime, or the right to organize. And they may not be protected against discrimination. This is often the case with farm workers, sexual harassment, and so forth. And you create this very much of a two-tier employment situation, where you have certain workers, people who be more like me, women more like me, who are lawyers, who I have leaned in my life. I've had a chance to ask for a raise, or not always successfully, but there's a certain amount of leverage that one has when one comes to when one has had the definite privileges that I've had. But then thinking about all of these other workers, and again, I come at it, I'm very interested in women, but I think one of the things that we need to understand is that these categories, which are dominated by women, are the job categories that are increasingly coming to include men as well. So it's a social phenomenon that we should not say is solely a women's issue. It's in fact an economic issue, and it's an issue of justice.
So I think as a lawyer, you're sort of suggesting that you can look at the laws on the books, and you mentioned a whole series of very important laws in the book, the Fair Labor Standards Act and the Civil Rights Act 64, the Equal Pay Act 63, Pregnancy Discrimination Act, and so on, but you're suggesting that there are often these kinds of loopholes or opt-outs or whatever that leave categories of
Yes.
people out. And Social Security could be included in that because, of course, it was written as a way, and you did your historical research, so women were supposed to get Social Security through their husbands rather than themselves.
Social Security is definitely an issue that needs to be reevaluated. But even, again, looking back at the New Deal time, the way it was written initially and administered was to prevent women and African Americans, particularly, of not having access to the program. And it's quite explicit in the congressional record. And a lot of it was because it was local administration, and in the South, they just figured out how not to administer it in such a way that it actually provided benefits to African American and women workers. But I think there's something that I've learned, almost as sort of embarrassingly after the fact. I spent almost 10 years working in politics in DC. I worked on the Hill. I worked in the White House for a little while. I actually drafted a few pieces of legislation. And as one does, especially as kind of a junior person, young lawyer, you look for a model. You look to amend something. And I wrote a bill called the Paycheck Fairness Act, which was to update the Equal Pay Act to provide stronger protections for women. And what I did was I grafted it onto the Fair Labor Standards Act because that's where the Equal Pay Act is attached. And the Fair Labor Standards Act has these limits. It doesn't cover certain workers. It doesn't cover small businesses, very small businesses. And as a result, I wasn't thinking. I wasn't even thinking about the women that might not be protected by this new law. It's just what you do. And there you can see that is very true in our anti-discrimination law. So Title VII is the provision of the Civil Rights Act of 1964 that prohibits discrimination in employment on the basis of race and gender or religion, now disability, maybe sexual orientation sometime soon. But it's in the original conversation, there was an interest in not burdening smaller employers. And again, there was quite a racist aspect to the discussion in that there were members of Congress who would say, well, it's one thing when, GM or some big business up north, where you have mixing. But it's another thing in our small communities where you have the local corner store or you have, some small farm implement dealer or something like that where, we should be able to figure out who we want to be with. And again, I would wish I were exaggerating, but you can go back and read the congressional record and you'll see how much more explicit the kind of the racism and misogyny were at that time than thankfully they are now. But so this is, I think, one of the things that we haven't yet addressed is that we've left these gaps in the law. Our employment discrimination laws don't protect workers in small businesses. And my thesis is that in many ways when we create these kinds of distinctions in the law where we say these workers aren't covered, we don't cover small businesses, we don't, business with this kind of dollar volume of business per year is not going to be covered. There are a lot of ways to game that system, and it creates perverse incentives for companies that will then start recategorizing workers. Instead of having a full-time worker, they have a temp or an independent contractor, and if you bring your number down below 15, all of a sudden you're not subject to all these laws. And I think, I'm not saying I have solutions to all of this, but I do think it's something we need to be conscious of about where the gaps are and what kinds of sometimes intended consequences that has created that I think we need to deal with as a society.
Right. So it's another way in which people can be left out. I was very struck by some of the terminology you used because, and I also want to ask you about some of the examples because they're quite striking, but at one point you say that there are people who would have to be called permanent temporary workers, which seems like an oxymoron,
Yes,
that a
indeed.
person can be a temporary worker, but in fact that is going to be their job, and that's one of the ways they can be left out through these loopholes.
Right. Well, and there's, one of the examples that I found, really eye-opening was Nissan has big factory in Tennessee. And they had a very large proportion of their workers were temps. And there are a number of reasons that they do this. One is because the temps get paid less than the permanent employees. The temps get fewer benefits. The temps are much easier to fire. And depending on the size of the temp agency then is responsible for being the employer. And that allows Nissan to just be much more flexible in how it deals with its employees. But these were temps. Many of them have been working for more than 10 or 15 years for the company. And what it did, again, was it creates this kind of bifurcated workforce where you have a kind of an elite group that are real employees and a sort of a subgroup that doesn't get the same benefits even though they're working with the same people in the same place every day. The other thing that I think is troubling to me is that temp agencies often a company will hire from a variety of temp agencies. Each temp agency tries to stay small. So each temp agency will be fewer than 15 employees. And then they'll hire from 10 different temp agencies to fill their 150 slots. Nobody's actually responsible legally for these workers because everybody's managed to outsource or not be liable for any of the, this affects, even occupational safety and health issues. One of the really tragic stories I read was about a hummus factory in Massachusetts. And they had been cited multiple times by OSHA, the Occupational Safety and Health Administration, for having a dangerous workplace. But the fines that OSHA issues are so low. And what they did was they were hiring temps who were untrained on the equipment. And one of these temps died. And it was just a business calculation for this company at the time. Rather than pay $8,000, they rather pay the $8,000 fine than hire and train employees for full-time positions. Instead, they kept having temps who didn't know what they were doing, and with really tragic consequences.
Yeah. And I think probably people in our audience have been reading the series in the New York Times about nail salons and nail workers, and the follow-ups make the same point that if you start going down kind of the rabbit hole trying to find out who actually owns the salon, who recruits the workers, there are occupational safety and health rules about inhaling chemicals or how many hours you work, but if you can't find the person who's employing a particular group, those occupational safety and health laws don't apply. And the other phrase that I thought was very striking when I read the book, you said, we're at a point now where a contingent workforce, that is a kind of a marginal workforce, has become the new normal in many parts of the American economy. You want to expand a little bit on that?
Yeah, well, one of the things, I think probably a lot of you know someone or may even be an independent contractor. And my brother is, by choice. He's a financial planner, he's a CFP, and there are categories of workers who want to be independent and have the earnings to be able to support paying their own Social Security and all of that. But there are a lot of workers who get categorized as independent contractors or temps, again, who don't necessarily want to or aren't appropriately classified that way. And what happens is that what we've done as a society is we've allowed the employers to basically put all of the risk on the employee by saying, you are not actually my employee, you are an independent contractor, and therefore I'm not liable to what happens to you if you're if you're a victim of discrimination. I'm not liable to you for overtime. I'm not liable to you for safety and health. And so all of these things that we tend to think of as societal, important societal objectives, safe workplaces and fair pay and all of those things, because of the way that we have allowed the manipulation of terminology, in this case the term employee, and I don't know how many are lawyers in this room, but our definitions around employment law are really come from the 19th century master-servant law, and applied to a very different kind of an environment than what we have now. But the same kind of rules apply to figure out who's an employee and who's not. And this has been is something that I was doing some research around for Under the Bus. Was, this was early in the Clinton administration. He actually had the Secretary of Commerce and the Secretary of Labor convene a commission. It's called the Dunlap Commission, to kind of look at the degradation of the employment relationship and sort of the protections that had been, that were no longer as strong as they had been when we adopted all of these very strong workplace laws. And they were really analyzing sort of the different and perverse incentives that this kind of outdated set of legal rules gave to employers, and how important it was for us to address the sort of master-servant law and update it to 20th century, now to the 21st century. Of course, nothing was done. And now you can look at the data, and you see that independent contractors and temps are an incredibly large, growing category of the workforce, and much of that is driven by the fact that it's a category in which the employer has no obligation.
Right. So the employee assumes all the risks of whatever is involved in sitting in your home and writing
exactly.
a blog.
And you see this with, that's the first thing I was thinking about reading about the nail salons. And I don't know if all of you have read it. I would commend it to you. It's a brilliantly researched piece. But one of the things I sort of was noting was that these are workers who have to bring all their own equipment. It's one way that you can categorize somebody as an independent contractor, is you require them to rent the space, you make them bring, and if you get your hair done somewhere, your hairdresser may be in this category. They pay a fee to the owner of the salon, they bring their own equipment, they have to clean up after themselves. They are sort of there, but definitely the employer will try and do everything possible to make the relationship be not one of employer-employee, but one of business and contractor. I'm not a frequent guest on TV shows, but I have occasionally done TV news shows, and I end up talking a lot to the makeup artists while they're doing my hair and the makeup and whatever. And they're in a similar situation, that they're never allowed to have more than 20 hours with any one of the networks. They bring their own supplies, and it's all in an effort to try and make sure they're not getting any health benefits, they're not getting sick leave, they're not getting overtime, they're not getting any of the other protections. But it's just something that we can see as a growing phenomenon, and that, again, I think there's a role for people who want to work independently when they want to, but when it becomes a way of giving those less virtuous employers the ability to manipulate titles and manipulate themselves right out of liability for any workplace discrimination or violation of labor laws. I think we really need to sort of re-examine that.
Right, yes. I like your description of employers, not so virtuous. Also the nail salon articles made it clear that many times the notion of being an independent contractor doesn't make much sense when you're talking about a very impoverished immigrant woman, somebody who may not speak the language and may have been recruited to come from a Latin American country or from Asia or whatever. And so there's no way that person can know that there are laws that exist supposedly to protect.
No, and the enforcement side is definitely a big part of it, and this comes out a lot with categories of workers like home health aides, nail salons, hair salons, a lot of places where you have workers who are either, don't speak the language all that well or less well educated, but really, how many people really know what the Fair Labor Standards Act says? Even I didn't, even when I was, doing labor policy, sort of thinking about those workers who are left out. Another type of, another discussion that's going on right now is about Uber and Lyft and the sharing economy. And this sort of is part of the discussion around the contingent workforce. One of the things that really laid bare to me, though, is, and I think it's a good product. I definitely think Uber, which I've used, not Lyft, but is speaking to something in consumers. But it caused me to go back and look a little bit at the taxi industry. And they're actually exempted from many of these laws as well. Many taxi drivers are independent contractors. So this issue is now coming out with Uber and Lyft. There has been a litigation that contests the designation of drivers as independent contractors. But I think the issue that's interesting to me is for the taxi industry, that's been the case since the Fair Labor Standards Act was adopted. And in New York, those of you who may be New Yorkers, you know that the taxi drivers, they're all independent contractors. The only thing they've been able to do is form a kind of worker collective around healthcare so that they can buy into a collective health insurance scheme. But it really makes the worker have so little leverage with regard to the employer because I think one of the things that we recognized when the National Labor Relations Act was adopted during the New Deal was that the right to organize is essential to allow workers collectively to have some ability to negotiate with an employer because it's very hard as an individual employee to negotiate on even terms with an individual employer. And I think so when the ability to kind of create a much larger set of independent contractors has eroded that ability to create collective solutions and where there may actually be a real need to.
Mm-hmm. Yeah. So the discussion of taxi drivers is a particularly interesting one, of course, because that's a more heavily male occupation than a female occupation. And many of the trends that you discuss in the book are affecting low-wage workers in general. But maybe we could talk a little bit more about how women workers, low-wage women workers, are disadvantaged by the kinds of policies you're describing, and perhaps what kinds of things could be done to improve their access to jobs with benefits. I mean, certainly you have several examples of nannies, for example, who seem very, very unprotected by any kinds of rules and regulations. But then you also provide us examples of the experiences that women have when they go into high-paying, traditionally male jobs and find that it's great to have the high pay, but then there are all these other things that affect them that don't affect male workers.
Well, I mean, I think that it's definitely a complex issue. I'd like to address a couple things. One is the tipped employee issue. So this is a category of worker that includes the manicure, the nail salons again, and the hairdressers, but predominantly the restaurant industry, of which, and 77% of workers in this category are women. We still pay, our minimum wage for that, for a tipped employee is $2.13 an hour. And there's the theory behind the distinction between a tipped level and the full minimum wage is that tipped employees will make it up in tips. But that's not really borne out by the facts. And this is a category of worker, and the sad irony of it is that food workers actually have a very high level of use of food stamps. And a very high level of poverty. Many of the women have children. A lot of them are single mothers. It's really a kind of I think one of our real failures in social policy is not to address this distinction. Number of states, 7 states, have eliminated the difference between a tip minimum wage and the full wage. That's had a powerful impact on women's economic well-being in those states in that type of work. So I think that's an important issue to consider. Overall, the minimum wage, 63% of the workers are women who earn minimum wage. So a minimum wage increase has quite an impact on the general family income. I think one of the things people don't realize is that minimum wage workers are not teens, not predominantly. They're actually people much older with family responsibilities, and that's been well documented. But I think that's an issue. Again, our minimum wage now is historically low, and that would have a real impact on women. The thing, though, that I think that sort of connects sort of more high-earning women with low-wage women and families generally are issues around childcare and family leave. And I think one of the things that we could do as a society that would have most significant ability to provide some stability to families would be to have paid leave, but also an affordable, accessible child care system, because we actually don't. We have a very small provision of publicly subsidized child care, but even in that category, only 18% of children who are eligible are actually able to get in because states are just not funding the programs at the level that's necessary. And there's a woman who I write about in Arizona who basically lost her job. She lost her job. The only good thing about that was all of a sudden she could put she qualified for Arizona's publicly subsidized childcare system, but there were 11,000 children ahead of hers on the waiting list. So, what does that do, to families, and then ultimately, what does that do to children? I think if we need to look at how do we actually provide quality, affordable, accessible childcare, and I think that would have the most dramatic impact for all families, because even for middle-income families, childcare, the way we have the privatized system that we have, is incredibly expensive and often in many states reaches the cost of the tuition of an in-state college. And so, I heard somebody say in an earlier discussion I had on my book that for people to start saving up for their children's childcare, they needed to start saving at 7 when they were 7. So that's clearly not a system that we can really we can continue with, and that is at least if we think that we are going to remain a society where women work. I think that's irrefutable. That is the society we live in, where 77% of women with children between the ages of 6 and 18 work. Single mothers work at a higher percentage, and even women with children under 6 work. Over 2/3 of them work. So I think for me, it's not so much is it good, is it bad? It is, and as a society, we have to recognize that we have small human beings that will be grown-ups someday who are going to be responsible for social policy in our economy in this country. And if we don't actually provide them with the kind of structure and support, that's going to have some real negative consequences for our country in the future.
Mm-hmm. And of course, as you point out, because you are the daughter of a historian, we did once provide good government-sponsored paid childcare at one point in our history, right?
Yeah, it's a very interesting story. During World War II, everybody knows about Rosie the Riveter. So Rosie, some Rosies had children. So in recognition of the fact that women were a necessary part of the war effort, Frances Perkins, when she was Secretary of Labor, although I think somewhat reluctantly, helped put together a child care program. And I don't think there was much approval for mothers working at the time, but the fact was that some of the women in the war effort had children, and there wasn't really any provision to take care of them. And so rather than have them be latchkey kids or what our Department of Labor actually now categorizes as self-care, isn't that Orwellian, self-care? They actually put into place a very small program that lasted for a short period of time, but it was a recognition of the fact that there were women in the workforce, and it wasn't a good idea to have kids be left at home. Some people were locking their kids in the car. I mean, there were just these stories that, as a government, the United States felt that had to be dealt with in order to make sure that we were sort of all pulling together during to win World War II. There was another time. And this was also quite an interesting story. In the early 70s, there was actual legislation passed by Congress that would have been sort of expanded Head Start in some ways and made it much more accessible to a broader category of families. Essentially was kind of an expansion of our public education system to younger children. And so the idea was to have a kind of a universal program as opposed to a poverty program. But there was right around the time of the Equal Rights Amendment, and there was the same groups that mobilized against the Equal Rights Amendment, mobilized against this child care policy. And there was one group that was called the 4 Ws. It was called Women Who Want to Be Women. And it was affiliated with Phyllis Schlafly and so forth. And they organized themselves, and sort of at the time was a kind of a massive write-in campaign to Congress, and ultimately they got to Pat Buchanan, who was working for President Nixon at the time, and he persuaded Nixon to veto this bill. And that was sort of the end of it. But so we almost got there. We almost had a kind of policy. But I tend to think that of all of the things we could do, really, just thinking about the multiple benefits for families and for the future generation, that having affordable and quality childcare is maybe the most important thing we could do.
Well, you clearly have stimulated this audience with many questions, and I'm going to try to organize them a little bit, but this question is one that I was thinking you were already talking about, so I think we'll segue to this, and that's basically what kinds of solutions you suggest. The childcare one, a very important one for working mothers, particularly when many working mothers are single parents. So are there other sorts of solutions that you'd like to tell the group that they don't give it all away, but they can read about in the book as well when they purchase it?
Well, I mean, I think there are a number of things we've already kind of touched on. I do think that for all families, raising a minimum wage is very important, but women particularly will benefit, and eliminating or at least reducing the difference between the tipped wage and the full wage will also be significant. I'd also think the Family and Medical Leave Act was a start, but the way it's structured right now, it affects companies only with more than 40 employees, and the employee specifically has to have worked 1,250 hours in the previous year to qualify. So that means there are a lot of workers who are actually not protected, and the dominant group that's left out are young women of color, and young families of color may be the most in need of family leave. But the other thing that is, I think, also a huge problem is that it's unpaid. And as I mentioned before, for a lot of families, having one of the parents take time out of the workforce, or if it's a single parent, and lose up to 12 weeks of pay is just something that is unaffordable. And there are really incredibly sad stories about women who had to immediately go back to work after having a cesarean and having infections, having hemorrhaging, having all sorts of things happen, not to speak of postpartum depression, and also trying to learn how to breastfeed and the need to bond with the child, that I think we need to really look at how do we move towards paid family leave. We are one of very, very few countries, not just among the developed world, but in the entire world, who don't have some provision for paid leave to enable parents to have some, sort of a healthy childbirth and then some bonding with the child. I think it's a recognition as a public health issue, let alone an economic issue, that's such an important public policy. I am happy to hear politicians start to talk about it. There have actually been some pieces of legislation that have been introduced. So I think of those areas, and we could go into occupational segregation and why it is that certain categories of work, such as teaching and nursing, are paid less than, say, truck driving or other types of sort of male-dominated professions. But I mean, that's a long conversation, but I think that's also an issue of how do we actually start to value work based on experience, training, skills, education, as opposed to the one category is filled by men and one is filled by women.
Right, yeah. And actually, I think you've answered this question, and then apparently somebody's following us on Twitter. The person asks, how does the U.S. compare to other nations in the way that we treat women in the workplace? And you
we don't rank very high, unfortunately. I mean, there are, the World Economic Forum does a ranking of sort of gender equity, and they look at a variety of measurements, including some of the issues that Lynn Yankel talked about in terms of women in leadership positions, sort of in political leadership, in business leadership, but also looking at issues around sort of the workplace structures of childcare and family leave. And we tend to come down, I think somewhere in the low 20s in looking at all of those measurements. We have some changes to make, I think, before we move up that scale. But I think it is a good way to sort of examine, how do we compare with countries that we tend to think of as somewhat like ourselves. But the thing that, one of the issues that I really like to sort of emphasize, and what brought me to writing the book Under the Bus was that we often think of these issues as sort of silos, like there's the childcare and the leave silo, and there's the wage silo, and there's the discrimination silo. And what really struck me as I interviewed a lot of women, a lot of retail workers, home health aides, other types of nannies, and other workers, that they suffer all of these things at the same time. So that's one of the things that I thought was, sort of really struck me as why we really need to come to some public policy resolutions, is that the same woman who doesn't have child care and paid leave doesn't get overtime or even earn the minimum wage, and she can be subject to sexual harassment without legal penalty and all of that. And I just thought this is really something wrong if we have a category of worker that's pretty much free from any of the protections we tend to think that we as a country bestow on workers.
Right. And I find that my own students, when I teach women's history, are quite stunned to discover not only the kinds of things you're talking about, but that the United States ranks so poorly when it comes to things like maternal mortality rates, infant mortality rates. I mean, Cuba's got a better rate than the United States on those. So there are lots of things that need addressing. And this is a related question. Is it a myth that the European Union does not have any of these under-the-bus issues?
It's a myth. Certainly they have some of the issues. I think they've been more forthright in tackling them. I was actually just at a conference where I talked to a woman who sits on one of the commissions. And they actually do have policies in place even to address occupational segregation, what we might call disparate impact processes to address the difference in pay between different categories of worker. But they will admit that on the enforcement side, they're not always as good as their policies are. So I think they have actually made more sort of strides in terms of policies and laws to address some of the issues. They're basically much better in terms of childcare and family leave. They definitely have ways to go as well in terms of wages.
So you're suggesting it's in part an issue of being aware and discussing the issues in public. And of course, most European countries have a higher proportion of their national legislatures being
Yes.
female. They also, of course, have national policies. The United States, and you point this out very nicely in the book, you have a patchwork of policies. It depends on where you live, and the different states have different kinds of approaches to issues such as child care policy, minimum wage, paid family leave, and so on.
Right.
Okay, looking around at this audience of mostly white women, you're singing to the choir. What actions do you think we can take to change the institutional norms and change the men how to fix the gaps?
Well, I mean, I do think part of it is just talking about it. So that is, the first thing is, I think, is raising these issues up and putting them in front of people. These are not, I sort of hate the term women's issues, and I don't like the segmenting into small little policy areas. And that's one of the things I think we need to do is really address that we have created very much within the sort of category of women worker, a two-tiered or more workforce. And I think we need to recognize as a society that if we have an ideal of trying to ensure fundamental rights, we can't give them only to one category of worker and deny them to another. So I think that is recognizing that there is a gender and racial impact of our policies around the minimum wage. There are gender and racial impacts around the exemptions we have from some the laws, and we need to sort of take a hard look at that and think about, what does that mean for us as a society? We are a changing demographic, but these are also, as I said before, I think they're categories of jobs. The service economy is growing. There are categories of jobs within the service economy that have been dominated by women that are going to be even larger, but have more men in them. Men are increasingly facing the kind of same deterioration of workplace protections. So I think, it's making common cause. I think partly we don't, as I said, don't want it to be women's issues. I think they're economic issues. And they're issues that, that I think go to the heart of how do we conceive our society and what sort of obligations do we have as a society to each other. But then fundamentally, I think you can look at the economic data and recognize that, increasing women's wages actually has an absolute important upward lifting for our entire economy.
Mm-hmm. And this is a very similar question. I think somebody, or maybe a lot of people in the audience, would like to be able to say, okay, there's one thing I can do this afternoon or tomorrow or next week that will help to get women out from under the bus. And maybe one of those might be pressing for raising minimum wages, maybe, you know, looking at how we tip women as opposed to men, maybe trying to discourage, it's happening in Philadelphia, discourage employers from saying your tip really should be 25%, not 20%, and it used to be 15%. And that's a way, of course, that employers can shift the burden of supporting a tipped worker from the wage
Right.
the employer pays to you and me.
I think people don't realize that. I mean, it's nice to be a generous tipper, but if, you know, when the employer then calculates at the end of the day what the wages are, they then deduct any of the extra tips that go to the company, and go to the restaurant. Not everyone does that, but I mean, that is a common, especially with larger chain types of macaroni grill types of restaurants. But no, I mean, I think it's hard to categorize. The one thing I do think raising the minimum wage is probably the most obvious one in front of us that we feel like has been making progress. A number of states raised the minimum wage in the last election cycle through ballot initiatives or in other ways. Seattle went up to $15 an hour. We're all probably a little bit cynical about what Congress will be able to do in the short term. And so I think states and localities may be the best places, but you know, as you mentioned, there are states and localities that have paid sick leave, that have paid family leave. Some I was just reading on the Post, in the Washington Post this morning on the train on the way up about the District of Columbia's early child care programs. They have a universal early child care as, again, part of their public school system. You know, so I think those are, I mean, not to discourage focusing on Congress. I think we should keep the pressure on, but I think where you can actually have your state or locality make a significant policy change, there's paid, you know, there's paid family leave in several states now, and that's from people engaging in local activism and moving their state legislature or their county council or their city government.
Mm-hmm. And maybe when there are debates in 2016, somebody
Absolutely.
can ask a question about family policy. Yeah.
I hope so. Hillary Clinton has already been out talking quite a bit about these issues. I'm hoping that she will be able to engage with, and if she's not the candidate, whoever is, with whoever the Republican nominee is, because I think these are issues that clearly the public wants addressed, because it's a conversation that keeps coming up over and over.
We have time for a couple more. You discussed independent contractors. I was under the impression once the employer dictates the time you must work and where, you have to work, that is, you have crossed a line from being an independent contractor to an employee. Do you want to maybe clarify that a little bit? I think this person is suggesting that if somebody hiring a janitorial service or hiring somebody to clean the floors in one of these office buildings around here, if that person doing the hiring says you must be here at 7 p.m. and you must clean these offices, that then makes the person an employee. Is that what happens?
Well, there's a multi-factor test, but I think the main issue is misclassification in this case, and that when you're actually, there have been cases where companies that provide janitorial services actually create a franchise for every floor in the building, and then they sell the franchise to individual janitors who then they treat as a contract relationship with them. There are a lot of abuses in the system, but I think one of the major problems is that this is so-called misclassification is very hard for someone who's mopping floors or cleaning bathroom in a building for them to understand whether the multi-factor test for employee they actually fall on one side or the other. And the Department of Labor recognizes this, that there has been absolutely abuse of the terminology and terrible under-enforcement. So under-enforcement is definitely a big problem.
Yeah. And if you don't provide federal funding for the enforcement officers.
Well, and again, getting back to these nail salon manicurists, to tell them that, because you need to show up at the salon at this time. But again, it's a multi-factor test because, as you see with the manicurists and the hair salons and so forth, they have to show up at a certain time, but you're bringing your own materials, But anyway, I think the biggest issue, though, is misclassification. It's a very hard thing to expect a low-wage worker to contest.
Two kind of related questions. One person asked, what role do unions have in dealing with these problems, and are you concerned about the Supreme Court's seeming hostility to labor? And the other is, so this is also on the solution side, would an equal rights amendment to the Constitution be an important solution? Help remedy these issues?
Those are big questions. I do think, one of the interesting facts about sort of the history of employment and labor in the United States is to see, very much the role that unions have played in addressing gender equality. And, they were not necessarily all that friendly, and some of them, to having women initially, although some unions have always been very much, the nurses' unions and so forth have been dominated by women. But the reality is that when you look at jobs that are actually unionized, there's a much less of a gap in wages between men and women, and much more likelihood that the workers will be entitled to paid sick leave and to paid family leave and the benefits that enable them to sort of have work and family, as well as the ability to control your schedule and and so forth. So there has actually been a significant role, and the public sector is one where it's sort of most obvious, where there are a lot of women workers, and very much has brought the sort of gender pay gap to the sector of our economy where it's the narrowest. But now we're at a point where the unions have declined so much, it doesn't affect that many workers. The Supreme Court has been part of it, but not only. In the Harris v. Quinn case, which I won't go into, and I know we're running out of time, but deals with home health care workers, which really put a crimp into the ability to provide greater protection to home health care workers through a union that was dealing with the state of Illinois. And so that has been limited by the Supreme Court. And so it's not clear to me exactly what will come next to the Supreme Court, but the biggest issue right now in the courts for unions that I could see coming to the Supreme Court is about public sector unions. And again, that's an area that I think is going to affect women, because women tend to be more represented in the public sector than in other places.
And when you shrink the public sector, you shrink the available
Yes.
jobs, particularly for women of minority groups.
Right, and they're good jobs.
Yep. Well, I am afraid that three of you will have to try and speak to Caroline afterwards to have your questions answered, but we are out of time. But I want to thank Caroline for a very interesting conversation, and mention that there will be a book signing immediately following this discussion. So thank you
So much.